Section 23, Option to have a registered constitution. 1. A company has the option to have a registered constitution. 2. Where a company opts to have a registered constitution, the document that represents the constitution shall be a. Signed by one or more subscribers or the company secretary, and b. Delivered to the registrar by the subscriber or an authorized representative before incorporation, or c. Delivered to the registrar by the company secretary, director or an authorized representative after incorporation. Section 24, Effect of Act on company that has lodged a registered constitution. 1. Where a private company has delivered to the registrar its documents intended to be the registered constitution, the rights, powers, duties and obligations of the company, the board, each director and each shareholder of the company shall have effect as provided in the second schedule, unless they are restricted, limited or modified by the registered constitution. 2. Where a public company has duly delivered the registered constitution of the company, the rights, powers, duties and obligations of the company, the board, each director and each shareholder of the company shall have effect as provided in the third schedule, unless they are restricted, limited or modified by the registered constitution of the company duly delivered in accordance with this Act. 3. Where a company limited by guarantee has duly delivered the registered constitution of the company, the rights, powers, duties and obligations of the company, the board, each director and each shareholder of the company shall have effect as provided in the fourth schedule, unless they are restricted, limited or modified by the registered constitution of the company duly delivered in accordance with this Act. Section 25, Effect of Act on company without a registered constitution. 1. Where a private company does not have a registered constitution, the rights, powers, duties and obligations of the company, the board, each director and each shareholder of the company shall be as provided in the second schedule and be deemed accordingly to be the constitution of that company, unless they are restricted, limited or modified by a registered constitution of the company duly delivered after incorporation in accordance with this Act. 2. Where a public company does not have a registered constitution, the rights, powers, duties and obligations of the company, the board, each director and each shareholder of the company shall be as provided in the third schedule, and be deemed accordingly to be the constitution of that company, unless they are restricted, limited or modified by the registered constitution of the company duly delivered after incorporation in accordance with this Act. 3. Where a company limited by guarantee does not have a registered constitution, the rights, powers, duties and obligations of the company, the board, each director and each member of the company shall be as provided in the fourth schedule and be deemed accordingly to be the constitution of that company, unless they are restricted, limited or modified by the registered constitution of the company duly delivered after incorporation in accordance with this Act. Section 26, Contents of Registered Constitution. 1. Where at incorporation, a company opts to have a registered constitution, the registered constitution of that company shall state a. The name of the company, with the last words of the name as required by subsection 1 of Section 21. b. The names of the first directors of the company, and c. That the powers of the directors are limited in accordance with Section 189. 2. Where a company has been incorporated in accordance with this Act and subsequently opts to have a registered constitution, it a. May state the nature of the business in that constitution which the company is authorized to carry on, or if the company is not formed for the purpose of carrying on a business, the nature of the objects for which the company is incorporated, and b. Shall deliver to the registrar 1. The constitution, and 2. A special resolution of the company to indicate the intention to have the registered constitution. 3. In the case of a company having shares, the registered constitution shall also state the number of shares with which the company is to be registered. 4. A registered constitution may contain any other lawful provisions relating to the structure and administration of the company. 5. In the case of a company that does not have a registered constitution, the company shall be deemed to have as part of the constitution under Section 25 the matters with respect to the a. Name of the company, b. Names of its first directors, c. Number of shares with which the company is registered, and D. Number of shares subscribed by each shareholder on the incorporation of the company and the consideration to be respectively paid for those shares as are respectively stated in the application for incorporation under Section 13. Section 27, Form of Constitution. 1. An unlimited company may have a registered constitution and the form of the constitution shall be in accordance with the form set out in the A. Second schedule, if a private company unlimited by shares, or B. Third schedule, if a public company unlimited by shares, or as near to those with the necessary modifications, but with a statement that the liability of the members is unlimited. 2. The registered constitution of a company may adopt any of the provisions of the appropriate schedule and subject to subsection 3, insofar as the constitution does not exclude or modify those provisions they shall, so far as applicable, be part of the registered constitution of the company. Skips clause 3 of section 27. Section 28, Subscription to Constitution. The constitution of a company shall be signed by one or more subscribers in the presence of a witness, who shall attest to the signing. Section 29, Effect of Company Constitution. 1. Subject to this Act, the Constitution but the effect of a contract under seal. A. Between the company and each member or officer, and B. Between the members or officers themselves by which they agree to observe and perform the functions contained in the Constitution as amended from time to time, insofar as they relate to the company, the members, or the officers. 2. Where the Constitution empowers a person to appoint or remove a director or any other officer of the company, such power is enforceable by that person although that person is not a member or officer of the company. 3. In an action by a member or an officer to enforce an obligation owed under the Constitution to that member or officer and any other member or officer, that member or officer shall, if any other member or officer is affected by the alleged breach of the obligation, sue in a representative capacity on behalf of that member or officer and all other members or officers who may be affected other than any who are defendants, and the provisions of Section 205 shall apply. 4. The registered constitution of a company shall be void to the extent that it contravenes or is inconsistent with this Act. 5. A registered constitution shall not be subject to a stamp duty. Section 30, Adoption, Alteration, Amendment and Revocation of Constitution. 1. The shareholders or members of a company may, by special resolution, A. Adopt a registered constitution where a company does not have a registered constitution. Or B. Alter or revoke the constitution of the company subject to this Act. 2. For the purposes of subsection 1b. A. The name of the company shall not be altered except with the consent of the registrar in accordance with Section 21. B. The number of the shares of the company may be altered in accordance with Sections 9, 59 to 65, 78 to 82, 219, or 239 but not otherwise. C. The businesses for which the company is incorporated to carry on, or, if the company is not formed for the purpose of carrying on a business, the objects for which the company is incorporated may be amended in accordance with Section 15 or 239 but not otherwise where the business or object is indicated at incorporation. D. An amendment shall not be made which shall conflict with an order of the court made under Section 219. E. If at any time the shares of the company are divided into different classes, the rights attached to a class may be amended in accordance with Section 50 or 239 but not otherwise. F. The Constitution may restrict or exclude the power of the company to amend all or any of the provisions of the Constitution or to add to the provisions of the Constitution, or may impose conditions for the amendment of the Constitution, in which event the Constitution shall not be amended except in accordance with the provisions of the Constitution or Section 239. G. The Constitution as amended shall be in accordance with this Act and shall contain the requirements under Section 26. H. Except in accordance with Section 239, a member of the company is not bound by an amendment made in the Constitution after the date on which that person became a member, where the amendment 1. Requires that member to take more shares than the number held by that member on the date on which the amendment is made. 2. In any way increases the liability of that member as at that date to pay money to the company, or 3. Increases or imposes restrictions on the right to transfer the shares held by that member at the date of the amendment, unless the member agrees in writing, before or after the amendment is made, to be bound by the amendment. 1. An amendment shall not be made which would have the effect of converting an unlimited company into a limited company or a company limited by guarantee into a company limited by shares, and J. An amendment may be restrained or revoked by the court in accordance with Section 218 or 219. Skip sections 31 and 32.